Good day. My name is Mark Mellor. I'm an attorney here at the Mellor Law Firm. I have some clients in Crafton, so I thought it would be helpful today to talk to you about mechanics liens and some of the things that you need to take a look at, whether you're a contractor or a homeowner, when dealing with mechanics liens and mechanics liens law. Mechanics liens are very strictly construed, so there's a lot of particulars in the law that you need to comply with. So it's important to know some of the statutory frameworks that we have to deal with in working with mechanics liens. The first thing you need to know, if you're a contractor in contract with a general contractor on a job or a homeowner that's working with a general contractor, the first thing you need to ask yourself is, when does a 20-day preliminary notice need to be sent to my house, certified mail, return receipt requested? The only time a contractor needs to send a 20-day preliminary notice is when they are not in direct contractual privity with the owner of the project or the homeowner. So if we have a subcontractor to a general contractor, they would have to file, serve by mail, certified mail, return receipt requested, a 20-day preliminary notice. If you're in direct contractual privity with the owner of a property or a homeowner on their project, then the 20-day preliminary notice is not required. And so one thing about the 20-day preliminary notice is you want to make sure that you send that within 20 days of first mobilizing on the project, because it covers the past 20 days of your work. If you file it at a later time, which you can do, that's all well and good, but it only goes back to cover 20 days of work. The next thing we take a look at is mechanics liens. Now when we look at mechanics liens, there's a couple statutory frameworks that we have to take a look at, time frames, and the first is, when can we record a mechanics lien? So a couple things to look at. You can record a mechanics lien within 90 days of the last time you were working at the project, or 30 days if the owner of the project just filed a notice of completion. Most of the time, notice of completion is not filed, so you have 90 days from the last time you did work on the project. If you go to work on the project and let's say you didn't work on it for 120 days and the contractor calls you back and has you do some other work, touch-up work or finish work, then we go from the last date of the project you record your mechanics liens, counting the last date. If you're a homeowner looking at a contractor that's recorded a mechanics lien, the first question you want to ask yourself is, has it been greater than 90 days since they were last working on my house before they filed the mechanics liens? If so, the mechanics lien is not valid. It will hold up your home in terms of recording process, but it's not usable if you file a special motion to have it expunged from the record. And then finally, once you record the mechanics lien, it's not over yet. I have a lot of homeowners that come into my office thinking, I've got a mechanics lien to get my house, what do I do? That's not necessarily a problem. Or if you're a contractor and you've recorded a mechanics lien, you think that's the end all be all. That's not necessarily the case either. What you need to do once you record the mechanics lien is make sure that within 90 days period of time you file a lawsuit to enforce or foreclose on the mechanics lien. That will perfect your mechanics lien and make sure it sticks to the property so it can't be expunged from the record. Those are a few of the things you need to look out for. If you have any other questions or any other construction matters, I'm happy to take a look at what you have. Feel free to give me a call here at the Mellor Law Firm.